because that's an agendized location for this meeting.
Okay, so what you're saying is Brown Act compliant all the way in what we're doing in terms of Mr. Page and where he's at right now?
Yes, because there's no members of the public there to comment that are being left out.
Great. Thank you very much. Sam, over to you.
And Mr. Page has joined the call.
Okay, so we all know Bob, welcome aboard. Nice to have you.
Thank you. Thank you.
Welcome, Mr. Page. We're glad you made it. Thank you, everybody here, for coming to this meeting. I wanted to welcome you guys, but I also wanted to say we're going to have a wonderful Blue Angel happening this weekend, and I encourage a lot of you to stay over and watch that. I also would like to ask this board here when they're going to have a night public meeting for the general public, as was promised. Thank you very much.
Thank you, Sam.
Donna Thomas, member of the public. I just have two questions. Mr. Chairman, I'd like to ask the status of the contract for the $90,000 USGS recharge study.
Okay, you have two questions?
And the second one is, several months back, I don't know if it was Dale Schaefer or Tim Parker, asked the question about whether or not integrated regional water management funding could be used or applied for to cover some of the costs of the GSA and GSP efforts. And I just wondered what the follow-up is on that.
We'll get you answers. Thank you. Thank you.
Good morning. My name is Mike Neal. Just want to address little generic stuff for recent events and statements, meetings, so forth have been going on concerning the business of this board. Mr. Gleason, I believe you spoke to, I believe it was the Republican Women's Group, and I saw the report in the newspaper. I'll assume they got it accurate. I believe there was a statement made about people that have some opposition to certain things that have been proposed or done in this board, and the terms used were small and narrow. I'll remind you that those people are your constituents, and they have a right to speak up and say what they think about what's going on here, and being marginalized by statements is unacceptable. That needs to stop. It needs to stop on the part of any particular person on this board who represents the people, and it's their job to remain respectful and considerate in their statements about those people. As opposed, and in light of certain recent meetings, number one we had, you're looking at me for some reason. Can you hear me? Yeah. Okay. I don't know. She was looking at me as what was going on. Okay. Some of those people, I guess maybe they're part of that small, narrow group, not real sure, spoken up recently about these bylaws that are on the agenda this morning, and basically what we've experienced is a near total lack of actually being listened to and having our comments, which we worked long on, listened to actually and actually considered. That's highly frustrating to people who wish to put their own personal time in and not being paid a dime or anything else to do that. We're just trying to do that for the good of our neighbors in this valley, and it doesn't come across very well when you get a group of people with over 50 years public policy experience together, put their heads together, craft stuff, proposed changes, and then it's like, we don't need that. Sorry, what we put forward is exactly right, and we don't need any changes. That also, as far as I'm concerned, needs to change. Am I out of time?
No, you have.
Good. Okay. Also like to point out something that's been distributed by the Deckers that I believe possibly has been brought up from the FPCC that talks about holding multiple public offices. And I tend to look into this and find out if the multiple public offices being held by the members of this board is proper according to California law, and whether this JPA is even legal in its very foundation. So I'm being polite enough to let you know what I'm fixing to do, and I'm not going to use denigrating terms towards you, not unless those kind of things continue on the board's part.
Excuse me, Ms. Neal, can I ask you a question just for a quick second? Because I'm not clear on your, I heard you say you had three questions. The small and narrow phrase that I used, the last one was the question about Deckers about the office representation on the board. But your middle comment, I didn't get what you were trying to say. So I want to get you an answer to the question, but I don't understand the question.
Well, it wasn't really a question. It was just a statement that in our presentation we have to go to, essentially we'd have to go to 3 separate meetings to try to influence the vote of this board, unless we felt like this board sitting here and these chairs listened to us, which as of the last board meeting, we did not. So we try to go to the water board. We try to go to the city. If you're in Bakersfield, I guess we come to your meetings, but 2 hours back and forth, kind of don't want to do that. But we go to those meetings. Certainly the water board meeting, we felt like the years were closed, where a lot of changes were proposed, and they picked one fairly minor one and another one which we proposed, which actually had already been proposed here before, so it wasn't really even a change. It was going backwards in time. So we just like to be listened to.
Thank you, sir. Appreciate it.
Let me just remind you that it will turn yellow when there's 1 minute left, so that you have a warning.
Okay. Judy Decker. I guess I'd like to follow up on what Mr. Neal said, sort of. That is that that the state voted in Sigma, which declared that you people would form this board, which you are struggling mightily to do. I attend the Water District meetings on a regular basis and have for the last 30 years. I hear what is happening at the city. And what I have to say to you is you are operating on this board in your position on the board to which you were elected. You were not elected by the people to this board. And you operate when you are on this board, and you operate when you discuss this issue with the board to which you were elected as a representative from that agency. But Sigma was formed to help the people. In this case, it's the people that live in the Indian Wells Valley hydrology basin. You do not represent all of us in equal fashion. And it has created, in our minds anyway, a big problem. And for instance, your bylaws you will be talking about, you have left out conflict of interest. That is a major problem, I believe, for you, in that what I just said. Peter is here representing the Water District, Mick is here representing the county, Peggy is here representing the city, the 2 other counties are here representing them. You need to represent us as an entity, as individual water users also. The people that live within the boundaries of the city are represented by all 3 of you, the county, the water district, and the city. The people that live out in the county are only represented by the county. So right off the bat, we have an unequal situation. And I think it's something you need to chew about on your own and come to a solution before you can go much further with a satisfactory answer. As I said at the Water District, we're having meetings, you're talking, people are pumping, and the water is going down, down, down. And Mother Nature is not going to give us a second chance. I'm sorry, it doesn't work that way. Mother Nature is not Santa Claus.
Thank you, Mrs. Decker.
morning, Mr. Chairman and members of the board. Derek Hoffman, legal counsel from Meadowbrook. Just as a general public comment, I think everyone here in this room especially is familiar with SIGMA. We are very aware of the mandates that it requires. We're aware of the time frames especially. But we hear a lot of a theme emerging that we have to hurry, and that the sky is falling, that the state is coming. And we are aware of the time frames, but to the extent that that theme and message is used as an excuse to overlook or ignore or skim over important policy issues, I don't think that ought to be a practice that this board ought to pursue. And instead, we should take the time to do it right. Thank you.
I agree. Thank you very much for your comments. Okay, we'll close the public presentations. I don't see anybody else. And so let's take a stab at answering them and make sure we get to either one. So I'm going to be tasking people to come up with the answers. Mr. General Manager, Mr. Christensen, could you please address the night meeting schedule?
I can. I don't have much to say. We, as a staff, were directed sometime back, if I recall, to sort of occasionally have night meetings to accommodate the public. We have not scheduled anything yet, but we could easily do that.
Okay, let's get a better answer for that. Let's look at a spring meeting to schedule an evening meeting to enable public participation, maximum public participation, and we can allow Mr. Page and Mr. Harrington to Skype in because now we're experienced at doing that. So, and we'll see if that produces better people participation. Is that okay?
Yeah, I asked for that before, and so I'm glad we're doing that. Thank you.
Thank you.
Happy
Let's
to
get
do
that
that.
going.
Happy to do that.
Mr. Parker, do you have the expertise and the capability to respond to the question regarding the status of the $90,000 recharge study?
Actually, I can.
Oh, okay. I'm sorry. I thought.
Yeah. I'm sure he could too, but I can tell you from the county's perspective, the Board of Supervisors, because the grant that we received from DWR runs through the county is going to spend the money. We approved on a consent agenda recently, just 3 days ago. Actually, no, that was the week before that. Sorry, the week before that, the County Board of Supervisors approved that agreement. So the agreements have been sent to the USGS for signature, so they can get started as soon as those get executed.
Thank you, sir. How about the integrated water funding? Or Mr. Harrington, do you have something?
Yeah, if I may answer Donna Thomas's question about the integrated regional water management funding. The Inyo Mono integrated regional water management plan actually includes this basin, and the Indian Wells Valley Water District is a member of that regional water management group. And yes, state funding is available for SIGMA planning and GSA support through that body.
So can I ask you a question? How do we access those funds? What's the procedure to go about it?
It's a state Department of Water Resources program that periodically sends out requests for proposals from these regional water management planning groups, either for planning or for implementation of projects, and certainly SIGMA-related activities would be eligible for that funding. It's a diverse group. Inyo County, Mono County, the Water District, City of Bishop, Mammoth Lakes, those Inyo Mono oriented groups, but it extends down here to this basin, and there's recognition within the group that there's important work to be done down here. The Water District has a grant or two through that program already. So, yeah, the answer is yes.
Great. Thank you, Mr. Harrington. Okay. You had the next question was small and narrow. There was comments. Mr. Neal, I believe, said that I would address the Republican women's, and I used the word small, narrow group of people. I did. You're correct. that is one that I did say. There's rumors flying around of things I say all the time, and I got to tell you, to be honest with you, I'm amazed people say what they say and how they attribute comments to me that are just flat out incorrect. It happens with regularity. I did say that. And the reason I said that is because based on the conversations I've had for the past 2.5 years with perhaps, I don't think I'm exaggerating to say thousands of people in this community, I would say that the percentage of people who are resistant to the success of the GSA are a small, narrow group. I'm not implying that the people who are trying to change it and to make it better are part of that group. What I addressed was the people that are opposed to the success of the GSA are a small, narrow group. And if it's any consolation, Mr. Neal, you're not one of them. And it was also, sir, made in not a derogatory form. It wasn't derogatory art. It was explicit. It was definitive. It was a small, narrow portion of the people I talked to, and that's how I used those terms. I was not denigrating that group of people because they have their opinion, and I'm all for it. You also used the phrase "paid attention," and I don't know if anybody else wants to comment on that. Mr. Neal lamented that it seems that the public feels that they're not listened to. I couldn't disagree with you more. That's not to say that I agree with you, but we will go out of our way, and if we're not doing a good job, matter of fact, I will take your counsel and I will try to do more, to listen to more people, because I think that feeling that you have and others, if it's shared by a lot of people, that you need to be heard. I hear you. I understand that. But don't confuse that with agree with you. That's all I ask. Anyone else have comments?
Yeah, I'd like to comment.
Please do.
So, not to be defensive or anything, but maybe I am. I gave everybody the opportunity to talk as long as you wanted to at our board meeting, and our intent is to listen. I'm sorry, but I'm not going to agree with everything everybody says, and maybe I won't agree with a lot. I have my perspective, I have my information, and I have my marching orders based on my position representing the ratepayers of this valley. That's my job. My job is to manage their resources, their money, to provide water. That's my charge. That's what we do. I listen to everything everybody says. I read every letter people send. But as Mick says, because we don't agree with it or we don't make those changes doesn't mean we haven't listened. It's probably because we just don't agree. Rather than having a large argument, a 2 and 4 dialogue that doesn't really go anywhere. Because if you disagree on a principle or disagree on a single fact, how are you going to come to a consensus of that when you just flat out disagree? So you can just say, well, and I usually end those statements with, I agree to disagree. And that's okay too. But I have a very specific orders, a very specific enabling act that tells us as a district what to do. But we listen to you guys. We listen to everything. We've made infinite changes because of the public participation. I don't like the anger sometimes that we have to face, but I realize anger comes from frustration, and I understand that. So we listen. We might not respond the way you want us to, but I'm hearing everything you guys say, and I'm sure Peggy and Mick do too. But you also have to remember we have the positions that we're elected to do, and that's the driver of what we do. And it has to be fair and equitable to everybody, and based on our jobs.
Thank you, sir. I want to talk next about multi-office. Someone had an issue about multi-offices, and can I have Mr. Hall comment on that from a legal perspective? Our responsibilities to represent, our responsibilities to parent organizations, and how they influence our decision-making here.
Give me 1 second. I'm actually pulling up the applicable code section. Yeah, sure. I'm getting it up on the phone here. So let's talk about this for a second. This was something that actually was brought up and we had talked about 16 months ago when we decided to form a JPA versus an MOU process. One of the reasons you chose to be a JPA instead of an MOU was for the specific purpose of having all of these meetings out in the open. JPAs they're sort of a quasi-public agency. And I say quasi because courts have never really had to deal with this section of the law. There's a section inside JPA law that says for the purposes of this article, a JPA is a public agency. Now, let's talk about what a JPA is. A JPA is a joint powers agreement. It is joint agencies jointly exercising their powers. So when you see these members up here, this is actually every public agency represented exercising your powers that you hold jointly. So the county is exercising its powers jointly with the city, et cetera. So, yes, it's a public agency. Yes, some things apply as a public agency, but not all things apply. For example, if you try to say that you would have incompatible offices, then you effectively could never form a JPA. Because who would the county or any public agency put on the JPA board if not their own elected officials? Because at the end of the day, there's a conflict in law right now. There's one code section in JPA law that says the JPA is responsible for its own liabilities and debts. There's another code section in the Tort Claims Act that says the JPA is responsible for the torts of the agency, but each individual member agency to that JPA is jointly and severally liable for those torts also. So if this JPA does something that creates a liability, creates a lawsuit, creates a tort, at the end of the day, Peggy's liable for it, Peggy is the city's liable for it, Mick is liable for it as the county. So obviously you want to have, if you're a county person, you want to have your elected official up there, not somebody who's appointed to. This is something we had dealt with 16 months ago when Meadowbrook and Mojave Pistachio were demanding to be on the board of the JPA, and we pushed back to say, well, that would turn over that liability to them. It also fits into another comment that we keep hearing about attorneys. You know, why are all of the attorneys from the public agency involved? Well, they're all involved because 895.2 requires us to be involved. Otherwise, tort liability of the county, the city, the water district is being exposed, and your attorney's not involved in the discussions that lead to that. So is there an incompatibility office statute? There is. Does it apply to JPAs? Not in all circumstances, and definitely not in this circumstance. And remember, we set up a JPA rather than an MOU specifically to empower the public. If we had done an MOU process, none of that would have happened. There would be no incompatibility office question. We would be up here as a committee jointly exercising through an MOU. It's just a different process. Incompatibility of offices is not a question for what's going on up here, and there's several reasons that then dive off of that as to why county has to keep involved, city has to keep involved, both attorneys, et cetera.
Thank you, sir.
With regard to one comment, and maybe it wasn't made specifically about the JPA or about the agency or the GSA. So everyone's clear. The JPA exists. It is formed. In 3 weeks, if there is no opposition, DWR will consider this JPA a GSA officially. So it will function as a GSA. That will be indisputable, we hope. So the struggle, I think, perhaps is something different, but not forming the agency. It is the JPA is formed, the GSA will be formed, and we're going through the process of creating an agency that functions and is going through growing pains.
Thanks, sir. Conflicts of interest. Peggy, do you want to talk about that?
I think, Judy, was that you who brought up the fact that there is no conflict of interest in here? And I wanted to address that. I believe it was in November, a conflict of interest was passed by this organization and sent to the Fair Political Practices Commission as required, and they had some questions with it. So rather than put something in that we knew they were going to maybe make comment or change and say, trust us, we're gonna change it when it comes, we left it out by design, not because we aren't part of that, not because we must comply with that, but because we will comply with it and we will comply with it as the Fair Political Practices Commission demands that we do so.
Thank you.
As soon as we hear back from the Fair Political Practice Commission, who is handling that?
So let's talk about this one for a second. There seems to be some confusion about what a conflict of interest code is and what it does. First, let's be clear. The very first resolution that this board adopted was a conflict of interest code. It's the very first act that this board did. Now, what is a conflict of interest code? Frankly, it's a very formalistic document that simply says who will file Form 700s. Form 700, for those that don't know, is a document that provides what financial interests board members or employees that are affected by a code have with the agency or could have. So, for example, board members have to put down who they receive their salaries from outside businesses. That's all it does. We passed one. The conflict of interest code, frankly, for this agency is very small. The only thing that you add into it is what employees are affected by the code. At that point in time, we put in general counsel. Didn't even have a general counsel at that stage. This was actually the very first meeting. Again, no general counsel is appointed, but we put general counsel in there because we knew we would have one. General counsel under our code has to file a Form 700 to the same extent that a board member does. Board members are called mandatory filers. As a mandatory filer, they have to file the most extensive Form 700s possible. There are cutouts then for employees. So, for example, if you're an employee that never has anything to do with property management, why would you file a Form 700 dealing with property management issues? You wouldn't. So there are carve-outs and categories. Right now, the FPPC, and the emails are going back and forth, the FPPC commented back that they wanted the general counsel categories, they thought. They haven't told us this. It has to be. Their initial thought was that it didn't need to be as expansive as a board member. I personally disagree with that. I'm filing the Form 700s. I think I should file the same as a board member. I think anybody member of the public would think I should file as a board member. And Keith does too, because he's general counsel now. Also, he's co-general counsel. So we have filed, and our initial Form 700 filings are on file. You could see my Form 700 if you want to. It's going to be boring. There's nothing in it. I don't have any investments, but it's there. That's all a conflict of interest code does. It doesn't do anything else. When we have employees, they would then get folded into the code as employees come on. Contractors will have to file Form 700s depending on what their work is. But there is a code adopted. It has to go to the FPPC for final approval before it becomes the final code. And for those that know much about conflict of interest codes, if I'm confusing you by talking about the FPPC on this, normally a code only goes to the county that the agency's in. Cities would be whatever county they're in. Special districts, whatever county they're in. This is a multi-agency FPPC filing because we have an area that's beyond one county. So to circle back, there is a conflict of interest code. It was adopted the very first thing because you have to do your initial conflict of interest code within, I believe, 60 days. And everybody has already filed Form 700s, and on April 3rd, we will file new ones.
Thank you, sir. Any other comments on that particular topic? Conflicts of interest are incredible. I mean, just unbelievable what we're seeing. I'm in a conflict. I mean, I represent the county, and yet I get my water from the water district. Yeah. I mean, the conflicts are just...
Well, maybe I should add that conflict of interest code, that's what everybody keeps confusing as conflict of interest codes because we've got one out there. Conflict of interest, this agency can't really establish much as a conflict of interest legally. That's what we have FPPC for, Government Code Section 1090. Those financial conflicts are part of law. They're not something that this agency can apply. Over and above that, if you want to have a code of ethics, you absolutely can, but frankly, there's not much you can do to enforce one.
Thank you, sir. Moving on, the last comment was made by Mr. Hoffman. I didn't announce, Captain Dale, thank you for being here, sir. Appreciate you being here. Mr. Hoffman brought up, I thought, a fascinating point, a true statement. What's the rush? Let's be thorough in what we're doing, and let's examine everything. Let's turn over every stone, especially at these critical stages. I agree completely. I think you're going to be satisfied, hopefully, from my perspective at least, by our discussion today. And I'm keenly aware of being painfully diligent in what we're doing and how we're doing. However, we do have deadlines. We got to make those deadlines, and we will make those deadlines. Any other comments about Mr. Hoffman's comment about diligence and what's the hurry? Okay, moving on. Go to the next category, which is special presentations. We have none. Next, item 5 is the consent agenda. If the board would like to discuss any item listed, any listed item, it may be removed from the consent calendar. We have in the consent agenda approve the meeting minutes of February 16th, 2017. Does anybody in the public wish to make comment on the minutes from last meeting? Seeing none, I'll close the public and bring it to the board for adoption of the consent agenda.
I'll make the motion that we approve the consent calendar.
Second.
Okay, I'm sorry. Did you, Mr. Decker, have a comment on the? I didn't see you there.
My comment has to do with I think it's.
Does it have to do, sir, with the consent agenda?
No, it does not.
Okay, well, thank you very much.
I wanted to provide a comment at the end of what you guys were talking about, a conflict of interest, which is a clarification of what our concerns actually are.
I'll give you 2 minutes, sir.
2 minutes?
Yes, sir.
You know, this very brief time before this board is a serious problem for the public, I think. I'm just not going to stand here and use my 2 minutes complaining about that, but that is a serious problem. Our interface is ineffective. All of you in your duties as a public office holder have taken the online ethics training. And there is a section in there on holding multiple public offices that I think you should all reread. And I'll read a little bit of it. There is such a thing as too much public service. The law limits the degree to which public officials can hold multiple public offices at the same time. The reason is that when one assumes a public office, one takes on responsibility to the constituents of the agency that to put their interests first. When one occupies multiple public offices from multiple agencies, for example, membership on the city council and serving on the board of another local agency, that job becomes more complicated both legally and ethically because of the possibility of conflicting loyalties. We're not talking about financial conflict of interest. We're talking about that exact subject. You were elected to your respective board positions, but here you are now serving in a completely different category to which you were not actually elected. You have a conflict inherently between this position that is talking about sustainability. That means controlling water and, for example, the water district's board members' responsibility, which is to pump water and serve their public. They are completely different, and they, in fact, conflict majorly. There is a section of this training that talks about incompatibility. It says, frequently offices are incompatible when one office has power over the other. Ultimately, this GSA is going to have the ultimate say on water authority. This is exactly the situation that we see looming, that's going to put you guys into a tremendous struggle to balance your original responsibilities against the new responsibilities here. That's what we're talking about.
Right. Thank you, sir. Appreciate it. I'll just make a comment and then I'll offer. It's a legal issue. Our definition as an organization is constructed in law, and we're here because of state law, and we will fulfill those responsibilities. But I agree with what you're saying. I sympathize with what you're saying. I get it. But I do that all the time. I do that as a matter of, I do that every day. Yesterday I was up in Kern River Valley, and I'm talking to people on one side of the fence, and then I go to the other side of the fence, and I get and they're bashing each other, and I'm trying to solve a problem, come up with some solution to satisfy what I think is in the best interest of the community. So this conflict that each of us has is part of, at least from my perspective, is part of my job. But let's get a legal answer from Mr. Decker. And I'd also like to say, before we do this, I think you bring up the public comment period is over, sir. But I think he brings up a reasonable a thesis that needs to be fully fleshed out, and we need a completely responsible authority, not saying that you're not, to answer his questions, because he has legitimacy to those concerns. So, Mr. Hall, could you talk? And then I would like to address this further. I don't want to give you a 2-minute window on this. I want to give us a true opportunity to understand what actually authority do we have, where does it come from, what can we do, what can't we do, and how does that interface with our other responsibilities as duly elected officers? Go ahead.
This issue has maybe more of a moral content than it does a legal content, and that is actually in this very document that I talked about.
Thank you, sir. Mr. Hall, would you please respond?
Sure. So let's talk about this for a second. So Mr. Decker brought up ethics training. Ethics training is part of what came out of a statute called AB 1234. That statute's probably 10 years old now, maybe 11.
6.
Since it's been out, I've actually been doing AB 1234 training. Beyond that, I'm very familiar with incompatible offices from my other jobs. And one of the key sections of incompatible office, and at first let's be also clear on this. It was only about 4 years ago that incompatible offices became a statute. Before that, it was just common law. 4 years ago, they adopted 1099. It's about 4 years ago. All right, great to hear. So part of what that statute says is if you're compelled, and I'll read this to you here, and this is the part that we are here. I mean, you are essentially compelled to be on this board if you were compelled or otherwise authorized by law. As I said earlier, the Tort Claims Act puts the county liable for the torts of this JPA. How would we not have a county board member then on this board? It just defies logic. If you're responsible for the liabilities of this agency, you're obviously going to want to be on the board. So the 1099 incompatible office section doesn't really apply. What Mr. Decker's speaking of with you can hold too much offices, absolutely right. And in fact, you don't even have to have a true conflict to have an incompatible office. You can have a hypothetical conflict in the future. And I'll tell you that almost every time, except for a JPA, every time I've looked at this issue, somebody's holding two offices, they're almost always incompatible. And here's why. You only need one potential incompatibility. And if that potential incompatibility is using eminent domain, that's it. And almost all public agencies have an eminent domain. The only time I ever found one that didn't was a busing district and a guy in a water district. They would never cross. But other than that, it's always going to be almost incompatible. The difference here is this agency, where you are essentially compelled, because you've formed a JPA, to have your members on it. Now, Mr. Decker started talking about the moral issue in that. I kind of understand where he's going there. I can understand how some people would think, well, JPA may not be the best way to do it. It's the only powers we've got, because you would have otherwise had to have formed a large water district for the whole area, the whole basin. You had to gone through LAFCO, formed it up, get the voting power in, and I believe I spoke with Mr. Decker about this 18 months ago or so. That's a task. And besides forming this large agency, the way Sigma's set up, every one of the agencies that's inside the basin then has to concede that they're going to let that agency be the GSA for everything. So is there a statute out there about incompatible offices? Yes, there is. Does it apply in this situation? No, it does not.
Thank you, sir. Okay. I think we answered that. Then let's move on to consent calendar. I need a motion to approve the consent.
You have it.
Oh, we have a motion, I'm sorry, from Mr. Brown.
And Peggy second.
Second over here. All in favor say aye.
Aye.
Opposed? No opposed. It passes. Item number 6. Discussion approval of bylaws for the IWBGA. Mr. General Manager, sir. Mr. Christensen.
Thank you, Mr. Chair, members of the board. We have this item on the agenda for you. since publishing this agenda, we've had some other public meetings with other public agencies who are on this board. It's a challenge for staff to absorb all that. We thought it would be best to get perhaps an update from I think the city met last night, like 16, 18 hours ago. So we haven't had an opportunity to absorb all of that. Nor, I don't know if you think there's anything in the paper yet. So maybe perhaps with your indulgence, we could turn the time over to someone from the city, perhaps the attorney.
Sure. Is this on? Yeah, there we go. I can hear you. I just like to think of this as just one continuous meeting. So let me give you a quick update on what's happened since the last JPA meeting. And I was asked to think creatively about some of the comments I got, so I'm going to try to give you a creative solution. We'll see how far that goes. So at the last, we had 2 city council meetings since the last JPA meeting. At the first city council meeting, we had the bylaws to consider, but at that point, the bylaws had only been out for just a few days, and we had a lot of discussion and concern from both the public and from the city council that they hadn't really been given enough time to properly go through that. We have very active members of the public that are highly educated, and they're very tuned into this particular issue, and they're very concerned not just with the things that the politicians say. They're concerned with the words in the document, as they should be. And they wanted the time to comb through the entire document and make sure that it was consistent with the way it was being presented to the public. They did that. They actually did that in a very short period of time, and they presented us not only with written comments, but even red line changes to the document, which was surprising given the amount of time they had. Given that material, the city council decided that it was, in fairness to the people who had done that work, they asked that this item be placed on the agenda today, which it was, and they also asked that staff provide comments back to the red line changes they had received. So county council and I, and also county for the district and staff went through those. We had to do it very quickly, but we went through those proposed red line changes and discussed it and figured out responses to each one. Some of the responses were to incorporate changes in the bylaws, and that's what you have here today in front of you this morning. So that resulted in another version of the bylaws being produced with this agenda on Friday, and they received that new version, and they once again went through it very quickly to see how they felt about our responses, and some of them they were happy with, and some of them they weren't. So last night we received another red line version, and that red line version sort of narrowed it down quite a bit from where we had been previously. So, where we had sort of accepted changes, they moved on. There was also some issues that they just moved on from, having heard our answer. They thought, well, that's reasonable, and they moved on. So what we have, and I was presented with this last night at the beginning of the meeting, so I'm combing through this and trying to get a sense of it. I still haven't completely got a handle on all of the proposed changes. But what I can tell you is, looking through them, this is where I was also asked to think creatively about how can we respond to this and yet move forward at the same time. And I don't think it's fair to the public who presented these changes to try to take action on those changes today. And I was asked by the City Council to make that pitch to the board. However, most of the bylaws at this point are no longer in contention. As a matter of fact, when I was looking through the changes we received, it's only Article 5, which deals with committees, and Article 7 that there were any proposed changes on in that document. Furthermore, we received comments from other sources, and to my knowledge, all of those comments also concern primarily Article 5 committees. So the reason, my creative solution, I guess you can call it, to this predicament is, what I would recommend anyway, or request on behalf of the city, is that if you approve these bylaws today, and I think you should, that you approve them without Article 5 and without Article 7, so that the various parties that have comments and additional concerns have the opportunity to air that out. We can parse through them perhaps at additional city council meetings, or I'm sure the district's very eager to take this up again.
Oh, yeah.
and whatever else is necessary, so that by the time we get a finished Article 5, at least everybody feels that they've been heard and had a chance to soak it all in. That's my proposal.
I would also like to add, if I may, Mr. Chair, there is a red line version that was given that we were asked to present to you all from the citizens who made that version, and urge you to read it, make comments back why things can and cannot happen, and respond in writing to that group of people and through the city as well.
Got it. Thank you. Mr. Brown?
I like your suggestion. Of course, at my board there was similar concerns, and the Article 5 was the one that created the most discussion. I was thinking, how can we make this work without having all these meetings? And so I was maybe going to recommend, would it be possible for all of us to get together and have like a workshop? And let's say we address 5 and 7 or whatever else. I would love to adopt the bylaws and get it started, pull 5 and 7 and whatever, and then have a workshop where in one day we can all agree in the same time, having lots of discussions, all the attorneys, all the agencies present, so it's done. Because as we all have our board meetings, we're segmented. The city has some things, we have some things, somebody else has some things, and it's almost impossible to keep incorporating everybody's thought process, especially over the time frame. We only meet once a month as Water District. You guys meet twice. So I would like to do what you suggested, and maybe to address the rest and maybe other things. Do it in a workshop where we can just, like Congress, all gets together and just hammer it out until they all go to bed.
Thank you. Let's have that conversation about a workshop after we finish this particular item, and then we'll dovetail into the workshop. So back to you, Mr. Christensen.
I do. Let me just point out, I'm in agreement. Kicking number 5 to a future meeting might be a good idea. It seems like some of the issues we have. It's Article 5.
Article 5.
So clicking Article 5 might be a good idea. In particular, it seems like some of the concerns are who should be on these committees. Frankly, moving that path down the road, I think that's the real big issue, is who's going to be on these committees. Moving that path down the road after you've had applications, it might be a good idea, because then you're going to know, and at that meeting you can adopt the PAC charter and the bylaws, which at this stage I'll probably combine into one document, and you could fill in those positions at that stage. So you'd have the applications in front of you, you could fill them in. You might want to change the PAC charter at this stage, the composition. I mean, now it says 2 domestic well owners. Maybe you want 3 to compromise, to level out the ag a little bit more. Not sure, but if you have applications in your hands, you're going to be more informed as you make those choices. And really, that's the choices you're being asked to make right now. People are wanting you to make those choices now rather than maybe changing the document after you start getting applications and filling it out. I don't see a problem with that. With that said, though, I would not. I think you should go ahead and vote on Article 7 today. Frankly, I don't even understand the concerns on Article 7. This section deals with what I had spoke of earlier about the Tort Claims Act, and it's conflict a little bit with the JPA law. The comments that we've received so far want to remove the second part of that section where it says, however, nothing in this article or in the agreements prevent or impairs the ability of a member or members from agreeing in a separate agreement to be jointly and severally liable in whole or part for any debt, obligation, liability of the authority, including but not limited to bond, debt instrument issued by the authority. That needs to be in here. We absolutely can't remove this from the document. That needs to be in there because that document says that if the city wants to do a special project and run it through the GSA, for example, groundwater recharge study, and they're the only ones benefiting from it, then they need to be the ones that are taking full liability for it. That's what that's saying. And you're going to have a separate agreement saying that. That is already in the JPA. The JPA provides that, and I believe it's Article 10, which talks about special projects. That's a very common document in, frankly, every water GSA I've ever seen. It's on all of the ones on the west side. It just says if you, the city, are going to have a special project, you need to be responsible for the special liabilities of that project. That's all it says. And I would remind everybody again that it says the city has to agree to that in an agreement. It's not a situation where this can be foisted upon the city without the city's 5 council members agreeing to that agreement and adopting it. So I don't see why we would remove that one. I was right, it is section 10.01, special activities in the JPA. This carve-out is specifically for that, and that's all that this section addresses is that.
Thanks, Mr. Hall. Back to you, Mr. Christensen.
So this item was before you, item, are we 5 or 6? I got too many papers in front of me. 6 was to adopt the bylaws. What I'm hearing from the city is that their desire is to, except for Section 5, to go ahead and do that. And an additional recommendation from one of the board members to have a workshop to work through Section 5. I would add to that, what I'm hearing is that we would go forward with applications for the PAC immediately. So we'll receive those applications. And as a staff member, I feel comfortable with that. We have some time to work through the other issues. Frankly, it's very difficult for us to, on the fly, react to what's going on here. And with so many suggested changes just happening hours ago, especially to Section 5, staff couldn't recommend going forward with that section. But we understand a desire to move forward and make some progress and to get the PAC going. So our recommendation would be a hybrid of, or much of what Mr. Lemieux has suggested. Adopt the bylaws without Section 5, take PAC applications, and then schedule a workshop so that the board can work through those objections or challenges with Section 5. That would be our recommendation.
Thank you, sir. Appreciate it. Let's open it up for the public, and let's hear what the public has to say about this conversation we're having. This recommendation, item 6, which has been changed, actually in line with Mr. Hoffman's comments that we need time to study Section 5, but that's the concentration of issues. Please state your name and begin your
It's Judy Decker again. I have some questions. I'm a little confused. You said, Mr. Hall, that in 3 weeks, if all goes well, this organization will be a GSA. If that happens, do the JPA rules still apply because now you're a different organization?
Mr. Hall, I'll allow you to comment because I think it's a one-word answer.
The answer is yes. The JPA agreement always it is the constitution of this body. This body will act as a GSA, and it has powers related to the GSA through Sigma, but it is a JPA and will always be a GPA.
Okay. You, Mr. Christensen, mentioned accepting applications immediately for PAC committee, yet there is no application. Oh, actually, I emailed you the other day. There's no application on your website. There's no document that tells what the criteria is for the various categories for applying. There's nothing one can find to read that indicates how you as a board will evaluate the applications. And I'd like to know when all this information will be available.
Thank you. We'll get that answer to you.
I think other people would like to know that also.
I'm sure they would. I would too.
Donna Thomas. I'd just like to recommend also that you hold off on approval of Section 3.8 on page 5, because that's intimately involved with the Section 5 section. The discussion at the City Council meeting last night, the major concerns were how the Water Resources Manager position will affect the roles and the authorities of the PAC. And so I think they're intimately connected. I'd say hold off on that one too, please.
May I respond to that, Mr. Chair?
Sure.
Keith had said last night that he had some concerns that some things that may change in 5.5 will affect 3.8. That's why I was surprised to see we didn't say 3.8. So is it okay if I ask him to say that?
I'd like to power through. There's a lot of conversation. That's going to be an in-depth conversation, and I want to thoroughly address that.
Okay,
but let's get through the public process first.
Stan Rotora. First of all, I'd like to thank Mr. Lemieux for what I think was actually a very good summation of what happened last night. Also, I may be speaking out of turn, but I really believe that on 7.1, I thought Mr. Martin had told you that we already were in agreement. Where we disagreed was really associated with that conflict that Mr. Hall was talking about earlier, which doesn't change anything, quite frankly, anyway, because we either have a conflict or we don't. We need to figure out how to resolve that. I also wanted to say before Donna beat me to it that the portion of 5.5 or some portion of 5 anyway, I don't have it memorized, is associated with 3.8, so I also appreciate the mayor's comments regarding we may want to actually put that into the pot as well, and that was something that actually Mr. Lemieux brought up last night. Who knows where else there might be some other conflicts, but the obvious one is 3.8, so I heartily concur with that. Thank you.
Thank you, sir.
Joshua Nugent on behalf of Mojave Pistachios and Nugent Farms. We would like to agree with changes proposed both written and in comments by Meadowbrook and others concerning the appointment of a legal counsel, an independent legal counsel by the authority, the rights of the public to directly inspect records by the authority that are not privileged, and Mojave and Meadowbrook should be specifically listed as a large agricultural representative on the PAC, and that Cereals Minerals should be identified as the industrial user representative. But our most significant concern is with the role of the Water Resources Manager and the PAC with respect to the preparation and implementation of the GSP. Section 3.8 should be revised to redact the sentence that states the Water Resources Manager should be responsible for preparing and implementing the GSP. This section should instead state that the Water Resource Manager shall be responsible for assisting the PAC and the TAC in the preparation of a draft GSP for consideration by the board and supporting implementation of the GSP. Likewise, Section 5.6 should be revised to redact the sentence that states the PAC will advise the board on the development and implementation of the GSP to instead state that the PAC will be the primary policy advisory to the board and will guide the GSP preparation and implementation with assistance of the TAC and the Water Resources Manager. These necessary changes are more than mere semantics. They are needed to make clear that the PAC and the TAC, supported by the Water Resources Manager, is the locus of GSP preparation. The current proposed language strips the leading role of the PAC in the development of the GSP and instead places this role in the Water Resources Manager. If the goal is to facilitate collaboration, buy-in, and consensus among the stakeholders, the PAC should be the principal body for preparing the GSP. We understand that with respect to the Water Resources Manager, our suggested changes reflect the wishes of many of the members of the Cooperative Groundwater Management Group and the current TAC. That is, those who are currently involved in the groundwater management of the Valley should lead the development of the GSP with support and not leadership or direction from the Water Resources Manager. Further, we understand that the current TAC could provide a detailed scope, schedule, budget, and work assignments for completion of the GSP using current TAC resources. This approach would be more technically effective, efficient, expeditious, and economical. Finally, we're really at a fault line here in the Sigma process. I urge this board to take the time to develop bylaws that will encourage cooperation and collaboration rather than approve the current bylaws, which will only cause conflict and strife. Thank you.
Thank you, sir. Thank you, sir.
Don Decker again. I'm back to conflict. The critical point that I didn't make earlier, but I will now, is that the exact conflicts of interest issues that the attorneys for the board members have recognized personally, that is individually, also apply for the exact same reasons to the board members, you fellows and ladies. It applies to you also for the same exact reason. To ignore these serious issues to the point of leaving the conflict of interest section in the bylaws empty is unacceptable to the public interest, because this is so critical to the function of your board, to be able to actually independently function as a board, not still tied to your member agencies. You are supposed to be independent. The thing that's missing is it's the answer to the question, under what restrictions can these conflicting multiple office functions be carried out? Everyone needs to know if and how these fundamental conflicts can be effectively mitigated, resolved. That's a fundamental question for you guys. It's not theoretical. You are holding multiple offices that are inherently in conflict. It's not your fault. The state has set us up this way with the JPA route as the suggested route, and the rush to get to the point of having a functional GSA. But to form a board that has a connection, an intimate connection to the responsibilities that you've got otherwise is, from our point of view, a huge detriment. You are crippled right from the start. I think that's all I have for today.
Thank you, Mr. Decker.
Sophia Merck, Sam, speaking for myself only. Thank you for taking another look at Section 5. Greatly appreciate that. And I'm sure that the public would love to work with you in regards to that. We all know how important the GSA is, but we all have to work together. You have brought up Section 3.8. I also recommend that you look at 3.2 in regards to officers of the board may be removed and replaced at any time with or without cause by a vote of the board. I have some concerns in regards to that. I also have some concerns that Water Code Section 10723 identifies public stakeholders. You should be looking at Native American tribes and disadvantaged communities. Actually, it can work in your we'll be able to get you some monies in regards to working through some 501c3s and so on and so forth. I have a letter here personally from myself, and thank you for listening to the public. That's all I got to say.
Thank you, Sam.
Sure.
You got a letter you want to drop off with us?
Sure.
Dale, if you grab that letter and distribute that for us, I'd appreciate it. Just give it to Dale.
Good morning, members of the board.
Good morning.
Mr. Chairman, Derek Hoffman, legal counsel for Meadowbrook. When we talked last and this board discussed how urgent it was to adopt the bylaws, one of the primary reasons given was so that you could establish the PAC and the TAC to do the heavy lifting. So to suggest removing the very article that covers those provisions does not make any sense to do. It's inconsistent with that message. And I would argue, and we submitted a comment letter today, you each have it in front of you, I hope that you've read it. There are 4 or 5 reasons why this board cannot and should not take action to approve any form of final bylaws today, whether including Article 5 or not. And so I'm just going to touch on some of the issues in our letter, and we'll just walk through it. I think that's the cleanest, easiest way to go, because it's been a very busy week. There's been a lot of discussion. The resolution that you have before your board was presented to you in the February 16 board meeting. And I'm just going to read Section 2 of that resolution, what it says, word for word. This is Section 2 called Adoption, regarding the bylaws. The bylaws of the Indian Wells Valley Groundwater Authority, in the form presented at this meeting, meaning the February meeting, and attached hereto and incorporated for reference, are adopted and approved as the bylaws of the authority, contingent upon the approval of the general member boards. If the bylaws are not subsequently reviewed and approved by any general member board, the issue will be brought back for action, will be brought back before the JPA for action again in March. If they are approved by all general member boards, in the February 2017 action shall be final without additional action. So there are 4 or 5 issues here. First, and I'd ask each board member representative to state for the record the specific date and time when your member agency, council, or board considered the proposed bylaws of February and approved them. Because we don't see noticed agendas for all the public agency members represented here today when the bylaws were considered by their respective board. Second, neither the Indian Wells Valley Water District nor the city approved the bylaws in the form as they were provided and incorporated by reference to the February resolution. Instead, the Water District approved a different version, a red line, in fact, from their agenda, and as did the city. A different version, not the February draft that was included in the bylaw, included in the February resolution. Third, there are many critical bylaw provisions. Oh, and I got to touch on that one other thing there. At the Water District meeting and the City Council meeting, both the representatives were directed to come here today and make a strong request to name Mojave, Meadowbrook, and Searles on the PAC in the bylaws. And perhaps we'll hear that later today, but the commitment was to make a strong request, and I hope we hear that when it goes back to the board. Third, there are many critical bylaw provisions that have not yet been drafted or even considered by the Groundwater Authority Board. Provisions on critically important policy issues, not legal issues, policy issues, like the composition of the Technical Advisory Committee, simply say reserved. Fourth, the February bylaws contain a number of objectionable policy provisions, again, policy provisions, that must be revisited and revised. We've identified many of those issues in our letter of today's date, and primary among those issues is not just in Article 5. It touches on the role of the Water Resources Manager, as you heard a moment ago. And the PAC and the TAC function, their roles, what they do, you've said yourselves that that role and that function is critically important. Next, the City Council approved 2 additional motions, and I'll be quick. Take additional motions last night. Thank you, Mr. Chairman. The City Council also approved 2 additional motions last night at their City Council meeting, and I don't think we heard them quite as clearly as I think the board ought to hear today. First, it approved a motion directing the city's representative to present to the Groundwater Authority Board today the comments and proposed revisions to the bylaws that were made by the Ridgecrest panel, and to strongly request the Groundwater Authority Board to review the proposed changes, consider and incorporate them into the bylaws, and to provide either compromise language or an explanation for rejecting any of the proposed revisions. Second, the City Council directed its representative, and voted unanimously to do this, to not approve the PAC charter today, due primarily to the fact that the Groundwater Authority Board has not considered that until today. And so, since none of the contingencies that were required for your board to approve final bylaws have been satisfied, we would urge the board today to not approve any form of final bylaws, especially not a version that excludes some of the most important provisions, and instead, consistent with what Director Brown has suggested, open up some public workshops, invite the public, engage in a very detailed, hard work, committed effort to present a full, final, agreeable set of bylaws with all the important provisions in place, and then allow this board to adopt a nice set of complete, effective bylaws so this board can get moving on the important technical work. Now, I do want to add one other thing. There are a number of policy matters that sometimes appear to be misconstrued as legal issues. It's critically important that this board consider the policy issues and view them for what they are. Don't morph policy issues into legal issues. I want to add in closing that we do appreciate the direction that the Water District and the city have given to come here today and request that Meadowbrook and Mojave and Searles be named on the PAC charter, both in the bylaws and for the city, also in the PAC charter, once that's approved. And we would urge the board to do that. And we appreciate taking that step so we can finally get going. The more entities you have named and ready to go on the PAC, the sooner we can all get to work on the really heavy, difficult technical matters that this basin needs. And I thank you for your time today.
Thank you, sir.
Mike Neal. Just a few specifics, but I'm going to address just some philosophical, I guess, basis of the approach and what we've now somehow or the other become known as the Ridgecrest panel. As part of that panel, one thing I want to make sure of is that everybody here has a copy of what we are recommending to be changed, and I do not personally have email contact info for Mr. Harrington or Mr. Page, so I need to get those so I can get those to you and be sure. I'm unsure whether even Supervisor Gleason has a copy of it at this point. I would expect he would, but I'll make sure you all have that so you can look at that. Now, as far as the heart of it, obviously, as Mr. Lemieux has pointed out, is in Section 5. And the reasons for the suggested changes in Section 5, without going into great detail on that, hopefully, Mr. Brown's suggestion is going to go forward. We're going to have a workshop and we can hash this out. We can discuss it because we had a long discussion about 5.5 last night. I think me and Mr. Lemieux never actually came to terms about that and why we wanted the changes. So obviously discussion is needed. We made these changes in order primarily to get proper citizen representation on the PAC, proper power to the people of the basin on the PAC, and get things in balance so that people won't keep coming up here saying we're frustrated, we don't feel like we're listened to, we don't feel like we have the influence. That was the primary motivation. That said, as far as what's been proposed by about 7.1, there are three of us here from the Ridgecrest panel who have actually said, okay, we will concede that. So 5.5 appears to be the point that needs to be worked out, and we appreciate an opportunity to do that. In regards to what has just been said, I'm a little, first I was going to say, fine, pass these parts of it and leave these Section 5 blank. I'm not real understanding as to why passing the rest of it is going to do a whole lot of good, since PAC and the TAC are really what's going to kick things into moving. So I would tend to say just don't approve the bylaws. Let's get that section worked out, and as soon as possible. Personally, I would ask you make this workshop happen after April the 3rd, because that's when I return from a trip. But you don't have to consider just me. Me and Stan are pretty much like this on it. He understands where I so we've done a lot of talking about this. So if I can't be there, as long as Stan's there, he's good. But I think there's some time frame when he's gone, starting next week too. So whatever we have to do, we'll try to do the best we can. I believe that's it.
Thank you, Mr. Neal.
First sentence, not everybody...
Could you please state your name for the record?
Judy Decker.
Thank you.
Not everyone has seen this copy that was of the bylaws, the latest one. That is, not everybody in the public. Not everybody in the public is part of this panel. I think, sorry to say, that you should wait another month. I think the idea of a workshop is great, but you need to allow the public at large to see what's being talked about here.
Thank you, Ms. Decker. Any other takers? Well, we got one more. Donna, please state your name.
Donna Thomas. I just forgot to give you my letter with other comments.
I think we got that already, but we'll take it. Okay, seeing no other further contributions, we're going to close the public hearing and bring it back to the board for comment and consideration. One more time to kick us off this conversation, reiterate your recommendation so we know what we're talking about.
Our recommendation would be to adopt the bylaws except for Section 5. Staff would begin accepting applications, and I would parenthetically say at about a week we'll have that on the website. We have to work out some language on that, but we would accept applications very soon. Per a board suggestion, we would have a workshop to work through Section 5 in the coming weeks, and that would be our recommendation. Did I miss anything?
Thank you. Okay, open it up for conversation from the board members. Any thoughts?
Mr. Chairman, I have a question.
Yes, sir.
What is the Ridgecrest panel?
Well, I was going to ask that myself because it says, is that speaking for the city or who the people on that? Or
you're not.
No, the Ridgecrest panel is a bunch of concerned citizens that took the time to band together to give red line changes to our city council.
When you say bunch of citizens?
I think there's, how many? And one of them includes one of our council members. And so I guess it sounds like there's 5? At least
the big 5.
I guess the answer is I don't know.
So they don't represent the city?
They don't represent the city as a group, but the city council last night asked that your representative present this to you for discussion.
Which I did.
Right. It's not necessarily the position of the city council, however.
Got it. Thank you, sir.
So the changes and discussion of changes relative to the bylaws as a result of their input, is that?
That's correct.
Okay.
And again, I think at this point, based on what I just heard, it's the changes we received, although you haven't seen them, are confined only to Section 5, which is under the current proposal not going to be approved. So in other words, you don't have to see those changes to at this point in order to approve the rest of the bylaws.
I might add for clarity, the Ridgecrest panel is what created the first staff report that's in there. So they came back with another set after the staff report.
Okay. Last night.
No, they didn't create the staff report. They created the changes that created the staff report.
I'm going to wait just a minute.
Oh, okay. I have one other thing. In Gresham and Savage's letter, the reference to the resolution for adopting the bylaws that came from the February 16th meeting, Mr. Hoffman inquired as to whether or not that had gone to the boards of the 3 counties. I don't understand this resolution to require that it go to the county boards, and it did not go to the INYO board, but there's a provision here for if it isn't approved by all the boards, it comes back to the authority board today, and that's what we're doing. I don't see any deficiency in not taking it to the county board.
Right.
If you'll indulge me for a second, he is quoting a previous draft. The draft that was approved by this board states, and I will read it. And Derek was here at the meeting. We handed him out. We read this change into the record at the meeting, at the last meeting. So I'm not sure why Derek is quoting the old resolution that was frankly never fully vetted. It got stuck in at the last minute because we had changes from the water district, and county and city attorneys hadn't got a chance to look at it, and it got changed and then brought to you, which we had discussed last meeting. But this is what the adopted resolution says. The bylaws of the Indian Wells Valley Groundwater Authority in the form presented at this meeting attached hereto are incorporated by reference and are adopted and approved as the bylaws of the authority until amended or repealed in accordance with law, conditionally upon review and approval by the governing bodies of the general members. If any governing body or of any general members so directs, this matter will be placed on the agenda for additional review and approval at regular meetings of the authority in March. If no governing body of any general member directs that this matter be placed on the agenda for the next regular meeting of the authority, the bylaws shall become effective without further action of the board. This was done because, frankly, Kern County wasn't going to bring the bylaws to the board. I believe Bob Page let us know he had no desire to bring them to his board either. And frankly, time frames for us at the Board of Supervisors for our counties, time frames don't allow it because we have such large agendas. It's like a 3-week process.
3-week lead.
Yeah, 3-week lead to get something on there, so you just can't do it. But I don't know why he's quoting the wrong one. This is what we've got. These bylaws, in fact, are not. They weren't adopted. This provision is applicable in that they were brought back, so the bylaws will not be effective as of tonight unless they're approved today. And we're asking you to approve them minus Article 5.
Thank you, sir. Mr. Harrington, you done?
I just want to add that it's also a moot issue in that if you take action today by resolution, it will, to the extent inconsistent, supersede the prior resolution anyway.
Thank you. Well, yes, Commander.
I have more of a question, Mr. Chairman. It's maybe my own confusion. Is one of the things that we had talked about prior to adopting the bylaws was potentially being able to move forward with PAC and the PAC membership to start holding meetings. And I believe the discussion at that time was, well, we can't do that until we put the bylaws in place. So I guess where I'm confused is if we put bylaws in place without Section 5, which talks about the PAC, how can we then move forward with the PAC?
I can try to answer that. We're taking applications. We would, so that we don't do this as a serial process, but we can do it parallel. Ultimately, the board will have to approve applicants to the PAC, but we don't want to slow that down. At a future meeting, they'll have to approve that.
Yeah, the other way to look at it is you can't have a PAC meeting until you have people in it. We tried to establish what its framework would look like and then fill it with people, but some in the audience thought, well, no, you can't do that. We want to have our position before you establish the framework. So we're going to take applications and do it that way.
Oh, so just to clarify, so we will take applications, but we won't actually evaluate or process those applications until the bylaws for the PAC are established, correct? Because the bylaws are what dictate the membership, correct?
Yeah, the bylaws and the chart. Right now we had a bylaw section and a charter section. As I'm thinking about this, when we come back, we're just going to have a bylaws, which will have the charter inside it.
Okay. But do you understand my confusion right now?
I think I do, and I'm trying to explain how we'll get there. So the application process will come in. Right now, we have set up a membership of what we think the PAC is going to be. Frankly, the bylaws are set up for it, and we had thought about you might decide to add positions in April. I don't know. You weren't going to know until you had applications. So frankly, now we're going to have applications, and then after you get applications, maybe you decide you want 3 domestic well owners instead of 2, because that's what the applications lead to, because you've got so much interest there. I don't know. But the process now, I would think, would be probably May. You would, maybe April we get lucky, but May you would, item 1, adopt all, pick whoever's going to be in, and then item 3 is adopt them with those names placed into the bylaws.
Okay, thank you.
Okay, I'll kick off my thoughts about this thing. I got several. I'll probably miss half of them, but I'll see if I can get some. Meadowbrooks and Mojave Pistachio, I agree with a lot of what you said. I think it's critical that you play, and I've said this from the beginning, a critical role in the establishment of how we're going to manage. I have never changed that coming from me and this board, to the best of my knowledge. So as far as your role on the PAC, I don't see it happening personally without you being there. Whether or not it's listed, the reason there's any discussion about that is because there's legal issues with specifically listing some people and not and forfeiting other person's ability to make the list. For example, if we're forming a representative organization where you represent large ag, well, if the 2 spots right now are taken to represent large ag, that removes, depending on how we define the difference between large and small, or if we define the difference between large and small, it will prevent other possible players from participating. We may, unfortunately, unwittingly, prevent other farmers from having a role to play in the conversation. So the conversations that I'm having with board members is not whether or not, it is how do we accommodate all. That's the issue, and how do we do that legally, because we're going to have to create an organization that withstands legal scrutiny. So that's what, maybe, I don't know if that answers your concerns or not, but that's my thoughts. I think that, my phone's going off. It's from Article 3.8. I disagree. I'm on the mindset, my mindset is that we need a water resource manager to craft who's experienced, who's independent, who understands water law, understands state guidelines, understands SGMA, is the pro from Dover, and that person is going to take inputs from the PAC and the TAC as he develops a water plan, a budget for us. I don't believe, after seeing this construction of how we're trying to get this GSA up and running after 2.5 years, that 2.5 years from now, we're going to have a group of people who are quite possibly untrained in water resource budgeting programs and knowing how to do that, whether they'll be successful. I think to have a lead agency who is sensitive to the concerns and accepts the counsel and advice and recommendations coming from the PAC and the TAC are going to be absolutely critical for him to craft a water plan that is specific to our unique nature. But I believe, in my mind, he leads that organization. Independent counsel. No, that was something else we talked about. Timelines for approval. This has been exceedingly difficult because of the process we go through, and I'm not prepared to make a vote on the whole bylaws, having just received comment from people this morning. I don't think we've done, the people who submitted the comments are having justice by us flashing through their comments and making a decision like that. I just don't think that's fair to the process. I don't think that gives the public confidence in our decisions. I think there's enough conversations that have been had in the water district and the city to warrant us to instead of supporting and approving the bylaws in total, to tap the brakes, to look at their concerns, understand their concerns, and if their concerns are focused on Section 5, whatever it is, then that's fine. Then I think we owe the public the ability to really help us come up with the best answers for Section 5. I also think that it's important that we move the ball. And I don't think we have to move the ball in serial function. I think there can be parallel efforts that are going to help us get some things in our rearview mirror while we still handle and tackle these big challenges that we have in the future. So I'm going to be the mindset to approve, to be a vote in approval of the staff's recommendation to move the bylaws, to approve them without the Section 5. I think it's Section 5. Is that whatever the staff's recommendation? Article 5. Article 5. And that's all for right now. I may have more comments later.
Mr. Chair, if I can make some comments. I want us to all remember that these bylaws, and I know it sounds trite to say, are not written in stone. They are changeable. And I have been directed by my counsel. I know what I am supposed to do. And so I am not opposed to approving the bylaws without Section 5, I think it was, or 5, whatever it is. Leave it out and come back and have a workshop. Peter and I had said, how can we do this better? There's got to be a better way to do it, and I think a workshop is, so we bring everybody in and ask and spend time and don't leave until we're done. Now, if we're going to be here 12 hours, you better plan on it, because we're going to be here 12 hours trying to get it done.
You can buy the pizza.
Yeah. And when we get that done, we will have the opportunity to look at it and how we're going to make it happen. I just want to make sure if we approve the bylaws, we are not approving the charter. I do not have permission to approve the charter today.
We'll clearly articulate that if that's your motion in our recommendation for that.
Okay. All right. Thank you.
Is Bob out there? Bob Page?
Yes, I am.
Oh, you've been so quiet. We don't know what you're doing. Are you doing something fun?
No, I'm just listening.
Okay, I hadn't heard you or anything. So, did you have any? I guess it might be like you. Did you have anything to add to this? I know that they had asked a question about you guys meeting as a board and discussing this, or how you guys handle this in your county.
Yeah, I can clarify that. I understood that the resolution that we passed at the February meeting was not the version that Mr. Hoffman read into the record today, and that our board did not need to proactively do anything unless it was the desire of our county to request a reconsideration. Our board's action to appoint Supervisor Levengood as our representative to this board and me as his alternate did not come with any strings that we needed to go back and check with our board on certain issues. But that is a discussion that he and I had, and we didn't feel that the approval of the bylaws was something that our full board would want to or need to discuss, so we did not take that to them. I did want to double check something on process for today regarding this recommendation. The agenda item in the packet indicates that there's a resolution to adopt today, and it also has attached to it a copy of the bylaws as they were adopted last month. I don't see in the packet online, I double-checked just now during the meeting, an actual copy of a resolution. There was a resolution attached to the charter item, but not to the bylaws item. And I'm also have a question of staff because I don't see a red line version of the bylaws in the packet. Should I assume that when the recommendation by staff is to approve the bylaws without Article 5, does that mean that I should look at the specific sections of the staff report where they indicate a compromise position or a recommended position where certain changes do be made? So when we talk about a red line, if I look at the staff report, anything where staff is recommending that some changes be made, that those are the only changes being made, or are there any additional changes to the February bylaws that are not included in the staff report other than the recommendation to remove Article 5?
Thank you, Mr. Page. We'll get an answer for you in just a minute. We're looking it up.
Okay, and then the other question I had regarding one of the public comments that was made, and I believe this was provided in written comment as well, there was a recommendation to expand the PAC membership to include disadvantaged communities. And my recollection is that the reason that Kern County in part was eligible for the Prop 1 grant that's going to allow for the USGS study and to pay towards the cost of this operation of this JPA as a GSA was because the area met the legal definition of a disadvantaged community. So I guess what I'm kind of wondering is when the public's asking us to include a disadvantaged community, my understanding was that the whole basin met the definition of a disadvantaged community. So my assumption was always that by making sure we had proper representation from the different water users, that we were, in fact, including representatives of the disadvantaged communities. But if staff could kind of clarify that for me, I'd appreciate it.
Mr. Page, we're going to have two answers for you. The first one's coming from Mr. Christensen, which will talk about disadvantaged communities, and the second will come from Mr. Hall or Mr. Lemieux regarding your concerns about red line edits.
Thank you.
Thank you, Mr. Chair. With regard to disadvantaged communities, we received the grant from one of the designations, at least from DWR, was that we are a disadvantaged community / county. So the entire county is a disadvantaged community. Now, we know that it isn't, but that designation allowed us to not require a match for the grant. And yet I have heard also that other grants may not have the same designation, that it may be more community oriented. But there is, and when asked, I think we were told, we hope that you are attending to the disadvantaged communities within the entire county. Of course, the grant that we received, half of it goes to Indian Wells Valley, the other half goes to the Kern County Subbasin, which has several disadvantaged communities. So I hope that answers. That's as best I can tell you definitively.
Thank you, Mr. Hall.
First, let's clarify something about Sigma. Sigma in no way requires people to be placed on a PAC. It doesn't say you will have people from these types of interests on the PAC. There's a code section in Sigma that says GSAs will consider the interests of these groups. Frankly, those groups are everybody that would have groundwater rights in an adjudication, plus disadvantaged communities, environmental groups. So Sigma, again, does not require that you have this type of representation on any committee. We keep hearing that, and I'm not sure where the confusion came from for the public. I'm not sure who put that out to the public. I have suspicions of who put it out to the public, but I'm not sure. But I will say again, that section doesn't say that. And if anybody doesn't trust me on this, I can tell you on the west side, none of these committees exist. Kern Groundwater Authority doesn't have one. The other GSAs doesn't have one. Koyama doesn't have one. What about Mr. Stiefwater's on Buena Vista, right?
I think so, yeah.
Did they form a separate GSA?
Yeah, and they don't have one.
And they don't have one. So it's not demanded. There's no requirement that you have these committees. This board, going back 16 months ago when we started heading down this path, has made every effort to be as inclusive as absolutely possible. And I think you're seeing that today by moving these bylaws without Article 5. Another thing, it sounds to me.
Could you please stay on the issue? The question was, does Mr. Page getting the edits? And is he looking at the right stuff?
I'm getting there. So what Mr. Page has, it sounds like he's got an old section of the bylaws, and we need to read the changes in. They're in the staff report. From what I'm seeing here, it looks like he's looking at the February 16th bylaws, which should have been in here to give you a reference. But I've got the changes right here. They're in the staff report. And for the record, I think we should read these in and the resolution. But I don't know if you want to do that now or if you want to wait.
Well, let me. Mr. Page is about to make a vote.
Okay.
I want to make sure he's got all the right information so he can make the correct vote. Does he have that information?
No, this has to be read in, but I wasn't sure if we wanted to have any more comment to the public response yet.
I don't think so. I think I just want to answer Mr. Page.
Okay.
And Mr. Chairman, as long as the changes are read in, I'll be fine, because I'm assuming that all the changes to the bylaws from the February version that we would be asked to approve today are the ones that are included in the staff report. I just wanted to make sure there weren't any, other than the removal of Article 5, that there wasn't any other change to the February bylaws other than what was in the staff report itself. And unfortunately, the agenda packet that was posted on the website doesn't include the resolution either, which I'm assuming you guys all have in front of you. So I appreciate that being read as well. I'll be comfortable voting as long as that's read.
Okay. Thank you, sir. We'll do that.
So if you like, let me read the bylaws changes. The first one is in Article 2 at Section 2.1. The first sentence now, instead of meetings of the board and any authority committees, shall be held in accordance with the Brown Act. It's Ralph M. Brown Act. Now has meetings of the board and any authority committees, including those with telephonic participation, shall be held in accordance with the Brown Act. And we've done that today, and we've done that in the past when we've had telephonic conferences. The next change is in Section 2.8. The third paragraph has been completely removed, and the new paragraph now reads, The voting on all matters of the board and committees, including minute orders, resolutions, and ordinances, shall be reported on the minutes and accomplished in a manner that readily signifies the action taken and the vote or abstention on that action of each member present for the action. There was a change in Article 5, but as we're not going to be adopting that today, I won't point that one out. Then we go to Article 8.6, which is a website policy. The authority, 8.6, website policy. The authority shall establish a public website where all pertinent documentation not specifically protected by law may be openly inspected by the public. Documents will generally include, but are not limited to, all agendas, minutes, resolutions, and ordinance of the board and its standing committees, all public written briefings, presentations, and correspondence of the board and its standing committees, and all public financial and technical reports that are not protected by law. Those are the changes to the bylaws. Is this the right one? So the resolution for adopting the bylaws today, it says Resolution, Section 1, whereas the attached bylaws regulating the affairs of the Indian Wells Valley Groundwater Authority have been presented to and considered by the Board of Directors, and the Board has considered public comments to the bylaws that were conditionally adopted on February 16th, 2017 board meeting. C, this board deems it to be in the best interest of the authority that the attached bylaws be adopted as the bylaws of the authority, and we're going to add here with the exclusion of Article 5 as shown in the attached bylaws. Staff has reviewed this matter and determined that it is exempt from further environmental review pursuant to California CEQA Guidelines Section 15378B5. Section 2, it is hereby resolved by the Board of Directors of the Indian Wells Valley Groundwater Authority as follows. Section 1, authority. This board finds the facts recited are true, finds this board has jurisdiction to consider, approve, and adopt the subject of this resolution, and incorporates all and makes all findings recommended by staff, whether verbally or in their written reports. Number 2, environmental review. This board finds and determines the action taken is exempt from further environmental review under California Environmental Quality Act of 1970 pursuant to 15378B5 of the state CEQA guidelines. 3, the bylaws of the Indian Wells Valley Groundwater Authority in the form presented at this meeting and attached hereto and incorporated by this reference are adopted and approved as the bylaws of the authority until amended or repealed by this board. Section 4, receipt of bylaws. The Secretary of the Board is directed to place a certified copy of these bylaws at the principal office of the authority and post the same on the authority's website. 5, effective date. The bylaws shall become effective immediately and remain in force and effect unless and until amended or repealed by the Board of Directors. And that's the conclusion of the resolution.
Thank you, sir. Mr. Page, you done with your thoughts?
I just had one last question. I heard Mayor Breeden indicate what authority she had been given by her city council. And I had also heard during the comments that there was some discussion at the Water District board meeting this past month. And I haven't heard whether Mr. Brown believes that he has been given the authority from his board to approve the recommendation staff is making to us today.
Thanks, sir. We'll get to that. Mr. Brown.
This is Mr. Brown. Can you hear me? Anyways, it was Section 5 that was the point that we had a lot of discussion on it, and the board had some very specific names that they wanted in there, like we'd been talking about all this time. So with this modification of omitting Section 5, I have the authority to vote on this today. So, you hear that, or?
I did, thank you.
Okay, good. You're just so quiet out there, and you come in much louder than we do. A quick thing. Well, I won't go into that. I'll make my comments later. So we'll keep it simple.
Bob, you asked me to. This is Peggy. I have permission from the council to vote on this, taking 5 out. and making sure that the comments from the citizens were presented, and we urge you to respond to and address in writing those comments. And we are not approving the charter at this point in time, not because we're against it, but because we did not have sufficient time to go through it.
Thank you, Mayor Breeden. Regarding the direction that the City Council wants us to respond in writing, we obviously don't have a document in front of us other than the staff report itself. With what appears to be some growing consensus to hold a workshop, if this board was to give direction to staff after we vote on this resolution to actually schedule a workshop, do you feel that that would satisfy the City Council's desire that we directly
Yes, sir, I do.
communicate with?
Yes, sir.
Thank you.
I need a motion.
I move that we approve the amended bylaws, omitting section 5, and then adding in the red line version that you had just read out loud for the minor changes that you've made.
Before I get a second, did you have a comment?
Motion needs to include the resolution.
Oh, okay, that we adopt the resolution that you'd also read out loud.
Well, thank you very much. Mr. Nugent, normally, I want to explain the process to you. You're not allowed to speak because public has been closed, but you've been standing up there and you've been doing so good. I'm going to give you 2 minutes.
I appreciate your indulgence. I would just like to formally request that you add 3.8 as well as 5 that are being viewed at later at this workshop since they're so closely tied together. That was it.
Thank you, sir.
Thank you.
So we have a motion. I'm looking for a second.
Second.
We have a motion and a second. All in favor say aye. Aye.
On telephone, we need to do a roll call vote.
Okay, so let's do a roll call vote. Dale, could you do a roll call for us?
Okay.
Put you on the spot.
County of Inyo, Bob.
Aye.
City of Ridgecrest.
Aye.
Gleason, Kern County.
Aye.
Indian Wells Water District.
Aye.
Peter. Bob Page, San Bernardino.
Aye.
Okay.
What? Okay, do they need to vote?
Don't. They don't vote.
Ex officio.
But they look good. Okay, so item 7, discussion approval of policy advisory committee PAC charter.
I think with this item, we will bring that back at the next meeting as part of a combined bylaws package.
Yes. We'll fold this into Article 5 of the bylaws.
Okay, so there's no action item required on items.
Correct.
7. Okay, number 8, report on plan of action milestones for groundwater sustainability plan. Mr. Christensen.
Mr. Chairman and members of the board, just an update. We said we would have this as a standing item, and as you look through the spreadsheet that's on the second page after the staff report, I just thought I would go quickly through some of the things that we're doing right now and that are upcoming. And I think the good news is we're pretty much on time. It's not the end of the world if we're not. But Mr. Parker had helped draft this for us, and I think it's serving its purpose. The third line down on the small type is adopt the PAC and TAC charter. That was for March. We're not quite there yet, but we're getting there, partially there. Next item is appoint PAC and TAC members, April. Committee scheduling, May. And then you go down to Water Resources Manager RFQ, March. We are confident that RFQ will go out soon, within the next few days. Responses received, April. Review, select, negotiate contract, May and June. Water Resource Manager starts work, that is July. So then there's other tasks that are down the list and down the timeline, but we are on track. I think it's good to review that and appreciate the thoughts of the Navy to get this started, and we'll update this as time goes on.
Thank you, sir. Do we need I guess we need a motion on accepting the report or receive and file.
You can receive and file. You can do nothing. It's
Okay, then let's do nothing. It's just a review of where we are. General Manager report, number 9.
Mr. Chairman, members of the board, let me get my notes here. Just a few things. We had a very good meeting. With DWR, Mr. Gleason and I went to Sacramento last week and met with them. We met with Arthur Hinosa, Trevor Joseph, Rich Juricic, and Tim Ross was by phone, and then a first name I can't remember, but a Miss Hong, also from DWR. Huh? Thank you, Hong Lee. And shared with them our progress. I think it was a very good exchange. Mr. Joseph applauded mixed leadership. I've just got some notes from that meeting. DWR recognizes that it's difficult to go through the process that we're going through. I had a subsequent call with Mr. Ross, who indicated that he thinks that there is a desert community just north of San Diego, and I'm not going to attempt to say the area, but he says they're going through a very similar process. It's a desert community. They have a large agricultural contingent there, and he is committed to try to come to our next meeting, walk through what they're doing, how they resolve the conflicts, and so forth. When we talked about monitoring, at some point monitoring wells, that might be coming, they nodded their heads and said that it makes sense. You cannot manage what you can't measure, and so I don't want to alarm anyone, but that concept is being discussed at the county level. With regard to all the basins that are in distress. There are some other things I could say, but that's the essence of the meeting. It was very good exchange. We were able to clarify some of the things that they had heard from certain individuals that may or may not be accurate about what's going on in the Indian Wells Valley, and I think we achieved that goal. So. That's my report on that item. We had last week we had preliminary video conference interviews with legal counsel who would be special counsel to this groundwater authority. Mr. Page and Mayor Breeden were on those video conference calls. Once we got through the technology, I think it worked pretty well. We interviewed 5 firms. At some point, some recommendations will come back from that committee or those members to the full board for a recommendation. We're still kind of processing that interview and the related information. One other thing. We received a letter from Brownstein, Hyatt, Farber, and Schreck, if I got that right. And we have not, and that went to Chairman Gleason. We had not responded to that. I've got a draft letter in front of me. I didn't get a chance to make copies and give it to you. I can read that letter, but since the chairman doesn't represent the entire groundwater authority, I think we were hesitant to send out a letter if it didn't represent the desires of the entire board. I can read this quickly. It's a very short letter. We received your letter dated March 1st, 2017, in response to a meeting request with 2 board members of the Indian Wells Valley Groundwater Authority focusing on financing the costs of groundwater plans and activities. We appreciate your client's openness to such a meeting. However, the board decided to ask for a meeting with the major pumpers in the basin without attorneys present. Rest assured that a meeting would not result in any decisions or plans being made, but rather to open a dialogue between parties. Ultimately, any decisions made by the authority must be done in public where all stakeholders can be involved. That is the law, and that is how the authority has consistently operated in its short existence. The authority's general manager, Alan Christensen, will contact you to make arrangements for a meeting. We look forward to that discussion. Sincerely, Chairman Mick Leeson, CC'd a number of others. So if that's acceptable, we will send out that letter to that firm, Mr. McLaughlin, I think representing Mojave Pistachio.
Let me just piggyback on that for a quick second, because I took the liberty of asking Dale to ask DWR to facilitate that meeting. If that may provide more help to get that meeting moving. So DWR is going to also take a role in asking if they could facilitate the meeting between the major pumpers and the two committee members that the board assigned to go meet with these the major pumpers. Does that make sense? Or am I late in the day? That makes sense? Okay.
If I don't get any opposition, we'll send out the letter.
Thanks. Any other comments?
One last thing. We terminated our contract with the county has terminated a contract with Parker Groundwater. We appreciate Mr. Parker's work on behalf of the county. As we've talked about, the county's budget is in such a state that we can no longer pay for that. It was time to we're in the middle of a budget cycle, and it was sort of out of our hands out of my hands to continue that. So I wanted to thank, on behalf of the county, Mr. Parker. If it's the desire of the board, the Groundwater Authority to engage Mr. Parker, they can do so. I think we have one of our attorneys developing some kind of agreement, but I wanted to announce that. I think all of you know that, but the public may not know that. That's it.
Thanks. Closing comments. Please.
Well, first off, I do want to recognize the awesome value that Tim has added to this committee and previous committees and functions that he's been with us in the Water District. Must be the Blue Angels, huh?
Blue Angels.
Good timing. Anyways, they're doing that for you. We're not sure how we're going to proceed, but we're going to help pick up some of the slack with the cost of Tim, because he's an extraordinarily valuable resource with his connections and with his history with the DWR, and I personally like his demeanor the best. It's kind of keeps everybody mellow. I like that. So just want to thank you, and you're not going away. We won't let you. I want to think about our structure in the future, not today, but I've mentioned it before, but maybe if we could do something like with standing subcommittees for very specific functions. I can use my own agency. It works pretty good. We actually changed our committee structure to meet better needs. But we have like an admin exec where we put together, we approve the, what do you call it, this thing?
Agenda.
The what? Agenda. Yeah, I'm thinking budget. Money's in my head. Things like that. So I don't know what you want to call it, how you want to work, but it might be an efficient way to bridge that gap of this long span and having this particular board, which is good, but to do all that busy work. I would like to also think about using the existing TAC. I know you told me it was physically impossible for them to continue to meet without Brown Act and all this and that. But it's so highly functional and it's working incredibly well. And they have a matrix of the things to do next and cost projections. You could just plug them in. It would be fantastic. So we could look at that, how that would work. They're great. And they're represented, all the major stakeholders are represented on the existing TAC, and it's highly functional. So I want to look at that. As far as the water resource manager goes, I always saw that position as kind of a guy that keeps everybody focused, not necessarily a control mechanism, but he puts everything together and kind of keeps everybody on focus, and then synthesizes or compiles everything that everybody's doing, not as a control mechanism, but as a process of keeping highly organized and moving forward. So I don't see him as somebody that's going to just listen to somebody and then do the wrong thing. I never thought that, and I don't think that's the intent. I think we're doing a good job. I'm real happy with our decision today. I really want to look at our existing TAC. They'd be easy to plug in and get going. And there's one last thing. our deadline is 20 years from now. Everybody, there's a lot of talk about, we're going to go away tomorrow. We're not going to go away tomorrow. We have a lot of water in storage, I want to make that point. For realtors, everybody, we're not going to go away. We have a lot of water in storage. What we're doing now is being proactive before there's an emergency, before we're reactive. And reactive is incredibly expensive and never works. Look around you. Deferred maintenance is the number one thing you can see anywhere. It costs a fortune to fix it after it breaks. So we're doing it before it breaks. And we have time to work with everybody based on everybody's needs and everybody's ability to participate. So we have time. We're going to get this going. I think this is a great start. But we have 20 years to have a plan that where the plan has to be complete and working. So we have time. So I just want to say we have time. So I don't want to go into a panic mode. Okay? Thanks.
Thank you. Okay, I got some closing comments. I agree with your comments about the water resource manager and how we craft that and interview that and ensure that he plays a role in a forward-leaning role in continuing the collaboration that we've done here. I think it's critically important. Okay, a couple things. I'll be as quick as I can. First of all, I want to thank sincerely from the bottom of my heart, and I know I speak for the rest of this board, I want to thank every person who not only comes here, I want to thank the Ridgecrest panel for the work you guys put in. I want to thank the people who voted yes, the people who voted no. I want to thank everybody who's done everything they can to help us, and I'm sure you're going to stay right in step with us every step along the way, and I'm incredibly grateful for that. Thank you very much. I want to talk about, I think the process we're going through isn't exactly, well, I know it's not efficient, but I think we can improve on it, and I want to tell you why I think it is. The state imposed this law on this basin. It says you will now the state is now going to regulate water in this valley, and they set up this local agency to manage that regulation for them. That's what this GSA is empowered to do, and that's what we are all about doing, complying with state law. In order to do that, we've tried to build this entity based on collaboration and consensus that can make decisions as best we can, understanding that we need to provide full transparency and ability for the public to comment and to participate. So what we've done is we've created a panel here that represents all the jurisdictions that have responsibilities in our basin. So we have all the public agencies who have water right authority or land reuse authority, and we got them up here and we say, okay, let's get all these jurisdictions together and let's collaborate and make decisions and find out where we can agree, and let's move forward. So we do that, and it works as long as everybody stays within their jurisdiction. When somebody exceeds their jurisdiction in the process, it's a house of cards and it comes crumbling down. For example, if our PAC, or if in the discussions the past couple of weeks articulated that there was going to be a city planner on the PAC, and I went back to my board down in Bakersfield and I said that this is what it's got like, and Leticia Perez or any other supervisor said no. I don't like the fact that there's a city planner on that board. So no, and by the way, absolutely, you cannot vote in favor of that board because I refuse to allow that, and somehow the Board of Supervisors agreed with that. That would be an example of, in my opinion, of exceeding the jurisdictional authority that supervisor has or that board has. The county has no right telling the city it can't have a city planner on the PAC. If the city wants to have a city planner, I'm going to sit there and say, that's a good idea, maybe I should have a county planner. Or I'm going to say, I understand, I can talk with you about it, but I'm not going to say to you what you can or cannot do as an authority in your jurisdiction. So I think that there are decisions we need to make that are impactful for all jurisdictions, where we all need to take a vocal role. And there are a lot of decisions we make that are not so impactful across all jurisdictional lines. So when we asked Peggy, and this is my opinion, I don't know what you guys throw legality at me, but this is what I'm thinking. When we asked Peggy to go back last week to gain city council's approval for the bylaws, I think we set you up. I think we did not clearly articulate to you, nor to Peter, nor to me, nor anybody, and with an understanding of what we need to do. I think what we were saying was, and I thought we said, but we didn't say, is that, Peggy, go back and review with your city council your jurisdictional piece of this puzzle and let us know what you guys think. And if there is sections of it that apply, any section that applies to your jurisdiction, let us know. And so I think that's different from how we go, and I'm getting skewed eyes looks, so maybe I'm not legal here, so I may be off, but this is just what I'm thinking. So that's what I thought the process was going to be like, and maybe it needs to be tweaked, but that's okay. But in order to do that, that would provide everybody boundaries for making those decisions. So that didn't happen. And I don't know whether what the law says explicitly, maybe someone can help me, enlighten me, and maybe I'm off my rocker completely. But I think if everybody stays within their jurisdiction, as long as the issue doesn't come into their jurisdiction and make decisions on the four corners of that jurisdiction, I think we'll be okay. Is there a legal comment to that? Am I off my rocker, or is that reasonable?
I would say that there's one, maybe two cases out there in JPAs, and they very clearly provide that the board members of the JPA have the authority to act on behalf of the JPA, and they need to do that. Going back to their independent general agency is not required. And in fact, even if they did something that their agency didn't like, their action at this meeting would count.
Got it. So I'm also not saying that if the city council chooses to say Mick nuts, and we want to have that's in your bailiwick, that's your city council, or it's your water district, or that's my county. And if that's the way my county wants to play it, I mean that's the way we play it. I mean I gotta take my marching orders from my fellow supervisors and do what is in the best interest of the county. But I wanted everybody to sit back and think about that as we go through our process. And if we can tweak the way we do things and everybody have to go back for every decision, that will enable our decision making to flow more smoothly, because one of the problems where we couldn't pass or get through the pack today is because we weren't getting the timeliness of the way we're going about it now is just completely, utterly inefficient and is difficult to manage. So please consider it. Talk it over with your boards. If I'm right, great. If I'm wrong, great. Let me know, and we can move on. A couple more items and I'm done. Lawyers. I've heard a lot of stuff about a lot of people, and I understand what people are saying about, we got all these lawyers involved, and all the lawyers are taking control, and the lawyers are steering it, and the lawyers are developing policy, and they can't agree, and all this stuff. I disagree. I think, they don't agree, but I think that what we're creating is a legal construct. We are creating a legal document and a legal framework from which we can develop policy, and we can distribute and debate policy. Because I don't believe that all the policy we debate and deliver is going to be accepted by everybody. And I think there's a chance that perhaps some of those policies or some of those decisions are going to be examined by outside agencies. And so we have to have firm footing on which to stand so that when we make those decisions, people will understand, okay, at least they had these legal components of their decision-making process together. So I'm hopeful that we all understand, I know it's difficult, that right now, or we have been, and until the PAC is formed, I believe there's going to be a strong role for lawyers to play in the development of this legal framework. Once our legal framework is developed, I'm confident you're going to see policymakers more involved, more vocal, and even more involved than they are today. I like the workshop idea. I think that's good. We got to set that up, General Manager. Find out how we can do that, why we can do this, and let's get that moving. You talked earlier about the meeting with the night meeting. I think that's important too. And I can't read my writing.
It says Captain St. Patrick.
It says packet. Okay, I'm done with my general comments. Anybody else have any closing comments?
We both did. Oh, you didn't? I did. I would like to ask some indulgence here because I'm expressing what's from my heart and not what's from my city council. I am asking you to give us the ability to learn from you, to listen to you, and to lead. That is what I believe we are supposed to do. I think that there is so much mistrust, and I don't understand it. You have said we do not listen. We have listened for probably 20 or 25 hours, maybe even longer. But it seems to me you have some responsibility to us, and we have huge responsibility to you. But you must give us the opportunity to listen, perhaps fail. I think not, but I'm hoping that we will continue to go on and go in the right direction. I don't understand the mistrust. I said to someone said, you're all out to, and I'm going to use a vernacular word, get to us. How? We have to live with this. This is us. This is our community. You are part of all of us. Nobody is immune to the results or the responsibilities of what happens here. Give us the opportunity to listen, learn, and lead. I'm asking that because I think we have shown you that we are trying to do exactly what you ask us to do. You may not agree with everything we do. I wouldn't expect you to. We would be innocuous in doing nothing. But I would expect you to understand we will do it now, or it will be done for us. It will be done with your dollars, no decisions, little input, and here you have the opportunity for everything. Give us the opportunity to do that and serve you. Thank you.
Thank you, Madam Mayor. I can read my writing now. I wanted to thank Tim Parker. I want to talk a minute about Tim and the work you've done and help us get to where we are. Thank you very much for all your contributions to where we are today. Thank you very much. And looking forward to your continued involvement. Okay, that's closing comments. Unless there... Yeah, Bob, do you have any closing comments?
I don't have any closing comments, though I did have a question for Phil regarding the vote that was taken on the consent calendar. That happened pretty quick. I didn't get a chance to voice my vote. Is that required?
It does, and you're ahead of me by about 30 seconds. I was about to say that we need to go back and roll call that vote. I was getting papers together and didn't hear that we didn't do that. So, yes, we need to roll call the consent calendar vote. Everything else has been fine.
Hold on a second. Mr. Page, did we get his answer? His question answer? Okay. Yeah. Okay, then I'm good for the roll call vote.
Okay. Inyo County, Bob?
Aye.
Ridgecrest, Peggy?
Yes.
Kern County,
Aye.
Nick? Peter?
Aye.
Bob? Paige?
Aye.
Okay, that closes closing comments. We'll look for a motion to go to closed session.
I'll make the motion to go to closed session.
So moved.
This is Alan Christensen, General Manager. No reportable action. We also, for the record, indicate that Mr. Bob Page is off the call now. He had some other business to take care of. That's it.
Outstanding. We're adjourned.